So our next speaker will be Professor Bruno Zeller from the University of Western Australia. And he is a leading expert in the law of CISG and has written and published extensively in this area. So, and his topic will be, of course, experience from Australia. Professor Zeller?
Here we go. Can you hear me now?
Yeah.
Okay. Look, the first simple comment is to make is that nobody's immune from the effects of the CISG. Whether it's applied or not applied is irrelevant, because one party could always have the CISG as the governing rule. And if you're looking at the statistics, that Hong Kong reported cases has been involved over 65 times with the US, Holland, and to see attack, of course, with China as well, with China even more. Now, the question about Australia now, this is unfortunately like a film, which we perhaps have witnessed before, which is the good, the bad, and the ugly. And unfortunately, Australia will fall under, unfortunately, the bad ones, because it's an excellent example of the mistakes can be made and the non-application or the false application of the CISG. And my view simply is that, start from the conclusion, is that the judiciary has not been trained sufficiently, and the legal profession have not been trained sufficiently to actually appreciate and apply the CISG properly. And that is a very sad story, because Australia is one of the first bunch of countries who ratified the CISG in 1988 or 89 or thereabouts. So how to avoid the problem? Now, Hong Kong, of course, has a great advantage, because the profession, some of the profession already would have been perfectly aware of it, because you have the Hong Kong, the Wismut East in Hong Kong, which is quite a successful moot and attracts quite a few solicitors or actually legal profession to participate. Now, or something I wouldn't mind suggesting here, if you're not aware of it, the University of Basel, by the way, in Switzerland, has launched a new website, which is an excellent website. And if you want to, I can supply the actual link if you haven't got the link yet. It's better than the PACE website. So a quick one, the Australian experience. So the unfortunate observation is that, simply put, they did not understand the effects of the CISG. And specifically, in my view, it's because the judiciary and the legal profession did not understand the ramifications and the importance of specifically Article 7 and 8. And that's where the major mistake is. And as far as I'm concerned, there's never been any sufficient training sessions in Australia on the CISG. So the first, and I'll go through some cases, which, by the way, you'll find in more detail in my paper, which I look at. The first one was the actual mention of the CISG is Renard Construction, where the only thing was actually said is that good faith was mentioned, which referred to the CISG, which of course is not known in Australia, but known in other countries. But then Roderzelt was the second case, where it's strange enough, the start of the application of the CISG was quite successful. Roderzelt correctly explained the interface between the CISG, and they understood at least the Article 6, and they left the retention clause to domestic law, not the CISG. So the start was all right, but unfortunately there was no guidance for future cases. Then came the next case in 1980. They have taken up with very factual descriptions and very little legal argument. the importance of the case was that much rather they did not connect the sale specifically to CISG when they talked about a fundamental breach. I said, well, this is a fundamental breach, and left it at that and did not explore it further, or that's the legal counsel as well as the judges, and didn't look, for instance, at Article 49, the Nachweis. Now, the excellent highlight and the better thing was Perry Engineering and Bernard. What happened there in brief was that the counsel, quite a legal firm, quite a big legal firm, argued that because the contract said the law of South Australia shall apply, they mistook that as being the sale of good. Oh, that's our phone. The CISG, that's the Sale of Goods Act. And they started to argue along the Sale of Goods Act. The judge, being astute in that case, said, but by the way, the law of South Australia means all the laws of South Australia, which includes the CISG, and hence you're arguing the wrong case. Go home, in simple terms, go home and start again. And that was the end of that case. I think they must have settled out of court on that. However, that understanding was lost in the next case, Ginza, where the fundamental mistake started to appear in the homeward trend, because many of the cases dealt with Article 35. And the councils always argued, basically, that the Sale of Goods Act shall apply. But what the judge said there, because the Sale of Goods Act is very similar and in effect the same as the Article 35, they proceed on the assumption that they're the same, and hence we apply jurisprudence and a legal writing based on the Sale of Goods Act. But interestingly also, looking at the cases as far as the information is concerned, there's some fundamental mistakes made in the application of it. They did argue 35, but my view and other people I talk to have the inclination or the suspicion that the time frame, that means Article 38 and 39, were not pleaded and were totally ignored, which means that basically that the result would have been completely opposite than what was actually achieved, and nobody seemed to be aware of that particular point. Playcorp, the next case, was exactly the same. There again, and courts have actually, the judges have said, so we'll just, because 35 and Section 19 are similar, or let's just proceed on the assumption they're the same, and they accepted basically arguments, language, and jurisprudence based specifically on Article on Section 39 of the Sale of Goods Act. Summit Chemical, no difference. There was absolutely no advance. And now what the problem that crept in is the old question of precedent. Judges started to refer back to the original in Ginza and all those cases and referred to those as being precedent, meaning completely the problem was persevered and repeated through precedent. And so there was never any change on that. Now, in effect, that way the case is stopped. Now, the next point was, which is an interesting case, it seemed to have been in the newer cases, a bit of a change, but not much of a change. And the one interesting case is Anti-Beverage Group versus an Indonesian firm. They don't know how that happened really, but the owner of the company had $10 million worth of taxpayers' funds And what did he do? He imported drinking water from Indonesia into Australia. The drinking water was dirty. And after the $10 million was spent, the case then was the question of liability. And they looked at the Consumer Act and the CISG, the Vienna Convention, basically, and they mixed the two together. They did not distinguish the point in that. And the question was, of course, the CISG was inapplicable if it's a consumer law, or the consumer law wasn't an applicable law in that case. It was a very confusing case and did not really go very far at all. And the last case, law in Windy Hills Australian Game Meet, 2019, that's a newest case. And Michael, they did actually quoted you. You're at the International Sales of Goods Act at the same time as Benjamin. So they were put it together as being the same. But there was no CISG jurisprudence and not much deliberation. The only point in that worth mentioning, I can read it out to you. They live with the goods to hand over what the respondent was obliged to deliver the goods, to hand over any documents relating to them, and to transfer property in them as required under Article 30 of the Convention on Conduct for International Sale of Goods, and deliver the goods to Mr. Law in his consignee at the named place of destination within a reasonable time after formation of the contract as required under Article 33 of the Convention. And that was it. There is nothing else. There was no elaboration on it. There was no explanation. There was no any academic writing or anything there at all whatsoever. And that's the way they're now understanding, at least the CISG, to be applied, but with no explanation, no understanding. But the point is, I said, it's the lack of understanding. This is where training courses, I think, must have a weight on, is Article 7 and 8. And as an example of the misunderstanding in Australia, is not out of the CISG, but it illustrates the point quite well, as most of you would know, is the model law on cross-border insolvency. And that has an interpretive article, which is basically the same as Article 7 of the CISG. And what the judges have said there, which is, of course, completely wrong in two cases, specifically Tannenbaum and Tannenbaum, they basically said, because the interpretation, we have to use the Vienna Convention on Interpretation of Treaties. Now, the model law is not a treaty. Therefore, that does not come into the picture at all. And then they went on to argue that, and I'll point it out, what they said, even when international convention or model law is adopted by Parliament in Australian enactment, that enactment and the adopted convention or model law must be interpreted in accordance with Australian principles of statutory construction. As you can see, it's definitely not an understanding of Article 7 and 8. But if Hong Kong wants to learn, then have us make people look at the Australian cases, and that shows exactly how not to do it. And we have not seen any, despite the fact there's a few of my colleagues are very well versed in the CISG, and there's plenty of writing, and the material is very handy, available on websites, the old PACE website and now the Basel University website. No use was made there, and the quoting of reams and reams and reams of domestic legislation to support an argument under the CISG is just utterly, completely wrong. And so I would say it's not only the bad, it's also an example of the ugly, like one of the Westerns, which some of us no doubt have seen. So look, that's all I really have to say about that. But as I said, just to recap quickly, training courses for the judiciary and the legal fraternity are most important. And then there's plenty of examples, like New Zealand is an example in understanding, I can't recall the exact case, but the Article 7 and especially 7 in the New Zealand case has been beautifully put together, and it's very simple to understand. And that should be the starting point for any training course to understand Article 7 and how it's actually applied and fits into the domestic application of the application to CISG. So Australia, as I said, not a good example. And look, that's about all I really have to say on that, because it's a very sad story and it brings tears to my eyes. But at the same time, lots of nice articles I could write as part of it as well, and criticise, which of course we academics love to do. Thanks very much for your attention.